Thank you for the stage. Hello, my name is Václav or Vasek. Like Adam said, I'm kind of a last-minute change, and I hope that I will live up to your expectation and especially to expectation of Petra. I'm gonna talk a little bit about regulation of AI for IT purposes. Um, I'm really glad that you've decided to listen to a lawyer speaking about 20 minutes about law instead of enjoying outside world on this beautiful day, but that was your choice, so I'm not here to judge. Just a quick words about me. Petra says about me that I have two great passions in my life. One is tracking hours in Legitas, where I'm attorney at, and the second is tracking kilometers on Prague pavements. I believe that she would be more happy if I had only one passion, the first one, of course, but yeah, what can she do? Well, let's speak about the content of this presentation. We're gonna start with a use case, so it's gonna be more practical, and then we're gonna delve more into theory, and after that, I'm gonna try to summarize at least what I think you should take from this presentation. Hopefully, you will take. The use case is pretty simple. Probably not many of you will come up to this issue, but it is a pretty common issue for lawyers, paralegals, assistants, who, when they are drafting a contract agreement, they need to put their definitions of the parties. That means its name, registered office, identification number, VAT ID number, and so on. These kind of information is publicly available in the trade register, but the trade register doesn't give you the option to, let's say, easily copy that information and put it into the definition. So you have to really just copy all of the information manually. And in this use case, let's look at the first part. Usually, lazy programmer means good programmer because he will try to come up with a solution that will do his work instead of him, and will not necessarily do it himself. And I'm not sure about the second one, if a lazy lawyer equals to a good lawyer, but in this case, hopefully it will. So the goal of this use case was to extract the data from the public database like a trade register or cadastral real estate, and just by one clicking on a button, take that information and generate a definition of that particular party into the contract. That means there will be a company called ABC, registered office at Porubska 86, VAT ID 2607.5. The method was chosen with a Chrome extension, and the situation was that I didn't want to do it because it would take really a lot of my time, because I'm not good at programming. I'm good at lawyering, but not programming. So I decided that I'm gonna use ChatGPT and ask ChatGPT to write the code and software for me. This is just for your idea how the final product came up. You can also download it if you're gonna want to use it. So this is the cadastral real estate. There's this particular real estate, and by clicking on the installed Chrome extension, it will extract the data and create a definition of that particular real estate. The same applies to the trade register, where we have the definition of that company. When I was using ChatGPT, the code and the software was more or less written by 90% was written by ChatGPT. The rest 10% was my human input in terms of the idea, in terms of the composition of data, in terms of finalization of that whole product. This is the final product of the extension package. And just for your idea how the original prompt looked like, it was really simple from the beginning. I just asked, hey ChatGPT, can you create me some kind of a Chrome extension that could extract data from a website and put it into some kind of output that I would use later. And ChatGPT already started with the composition of the whole Chrome extension. This is the finalization. I was happy with all the functions, so I asked it to just prepare downloadable file so I could use it. And during the process, I was working with ChatGPT on that code. There were some issues that needed to be resolved, that needed to be fixed. This is one of the examples. This is for the trade register, because I need to say that the company is registered at some kind of a court, regional court in Ostrava, municipal court in Prague, and so on. And the original code, what it did was that it abbreviated the name of the court. So instead of that I wanted to say that it is registered at the regional court in Ostrava, it said that it is registered at RCO, which is not ideal. So this is kind of the issue I needed to be resolved. Another part of the process was debugging, because I came up with a lot of bugs that needed to be resolved. There were two solutions for me. One of them was I can try to fix it myself. The second one was that I can try to ask ChatGPT to fix that problem, and I just can copy the fix. Obviously, I chose the second one because I'm not good at coding, and ChatGPT did it for me. So I just put a prompt, hey, I came up with an error, what can you do? So the artificial intelligence edited the code, and the issue was resolved. So again, for the summary, the whole idea was human, but the code was written by AI. There comes a great question, as in case where my inner lawyer, let's say inner lawyer, came and said asked a lot of questions, because I created a software, and I wasn't sure if I have the rights to that software. Is it a copyright work? If it is, am I the author, or who is the author? Is it protected, or is nothing protected? There were a lot of questions, and before I try to answer them, I'm going to try explain a little bit of theory about the whole situation. If we talk about software and its and related rights, we talk about intellectual property rights. It is a big group of rights which is divided into two groups: copyright law and industrial rights. Not every, but many of the elements of that software, in terms of source code, in terms of UI, documentation, and so on, can be covered or protected by a different element of intellectual property rights. Then we're going to talk about a little bit more about the copyright to the work. So I will try to answer if that software is really a copyright work, even if I didn't do it, but did it the artificial intelligence. And the third part is kind of a hint for you, whether it is a copyright work or not, because I'm going to talk about NDA and non-compete agreements, which are part of the other form of protection for my source code and for my software, apart from the copyright rights. So, as I said, different elements of software are covered by different parts of intellectual property rights. And if we look at the parts of the software, then we can see that probably the source code, user interface, documentation could be covered by copyright. Database obviously will be covered by database rights, and for example, name or logo of that software could be covered by a trademark. The most important part for me when we're talking about software is the copyright law. Software is a computer program which is a literary copyright work, and there are some conditions for that needs to be met in order to have a copyright work and in order to have the rights to that software. That computer program has to be created by a human. That is the let's say main condition. It has to be to some extent creative, but unlike other literary works, for example, if I were to write a book, it would have to be also unique. I couldn't just copy someone's book and say, hey, I got a new book and I have the rights for it. So this is the case for other literary works, but for computer programs, we don't have that condition of uniqueness. So the main two conditions are it has to be created by a human, and it has to be some kind of a creative expression of that programmer. So if I have the right to a copy, I'm still talking about the computer program which was developed by me and not by AI. So in general, when I have a copyright work, I can I'm gonna be selling a software. There will be usually there should be a licensing agreement. In the licensing agreement, we're going to talk about if it's going to be exclusive or non-exclusive. That means if I'm able to license it to another person or just that particular person. We're going to talk about how long will be the license for, its territorial scope. So if the user is going to be able to use it in Czech Republic, in European Union, or the whole world. We're going to talk about the types of use, also obviously the licensing fee, and other related parts. And now let's get back to the use case, because as I said, the software, in order to be a copyright work, it has to be created by a human. But this use case wasn't created by a human. It was by 90% created by AI. So will it be covered by the copyright law or not? Show of hands, who here thinks that it should be covered by a copyright law? Okay, and who doesn't? It's more or less the same response, okay. And the answer from a lawyer is, I'm going to use, let's say, standard answer, it depends. We're not sure. There are two big groups of lawyers. One of them says, if you're creative enough and your input is really complex, it's not just a plain, simple prompt, hey, ChatGPT, do this, and it's going to be a lot of debugging, a lot of editing of that code by myself, by the programmer, and not just the artificial intelligence. They say it could be copyright work. But there's also another big group of lawyers who say, even though you will play with the code, it was still created by artificial intelligence. Therefore, there is no human behind that work, so it cannot be copyright work. Then there comes another question. If we were to decide that software is a copyright work, and someone has rights to it, who will? There are four, maybe even more than four, but there are four main possibilities who will be the author. Of course, the first one, no one, because it is not a copyright work. Then it could be author of the output. It could be author of the input who actually put the prompt. And it could be also author of the training data, because ChatGPT trained on the data, and based on the data, it was able to develop that software for me. So the question is, should the author of the training data should he be the author of the actual software? Again, as of this time, there isn't any case law, any regulation in the Czech Republic, in the European Union, or in the US. We still don't know, we are not sure whether it is a copyright work and who is the author. To somehow, if I were in the first group who says that it could be a copyright work, then in order to mitigate the risk that someone would come to me and say that I don't have the rights, this is something I would do. This is something I would do. So it would be archiving of the prompts and procedures, so I could prove that there was enough human input from my side, and that I'm actually the author. And if I were on the second group and saying that it isn't a copyright work and no one has the right to it, then I would go for another form of protection of my source code, of my software, and that would be NDA and non-compete agreements. Those two could be combined together ideally, and the NDA means it is a agreement that obligates the person who I'm going to entrust that information, entrust the source code, entrust the software, that that person will not be able to disclose it to anyone without my approval. The non-compete is that that person will not able to use it, that knowledge, that know-how in competitive, directly, indirectly activities. I've seen a lot of NDAs and a lot of non-competes, and many of them weren't really perfect. So if we're in a situation where we don't know if I have a copyright rights to that software, I should at least have a bulletproof NDA and non-compete. At least the NDA, because I've seen NDAs that didn't cover the situation where the original contract was terminated and what happens next. I want that person obligated even after we terminate our contractual relationship, and I want him to keep all the information secret, even for eternity. So these two are the main other forms of protection of that software. But also keep in mind that there's still a group and there's still a chance that somewhere in the future, even though that software wasn't created by a human, but it was created by AI, there's a possibility that some court will say that it is a copyright work, and therefore I should still keep in mind that I should archive and document all of the prompts and all of the procedures, and also still think about that that licensing agreements are still essential. So even though there's a possibility that my licensing agreement would be invalidated, there's still possibility that it could work. So ideally, I would combine all of these together. So I would have the licensing agreement, NDA, non-compete, but that's an ideal world, and we're not living in there. So at least I would try to aim in that direction. This is probably all from me. So if you get any questions, you can ask them right now, or I will be in the speaker's corner, and we can grab a cup of coffee and talk a little bit more about that. Thank you.
It was very nice ending with the theme. Okay, so we got basically no questions in event here. Does anybody want to ask a question from the audience? Yeah.
Is there any difference between like AI and non-AI generative code? Because during development, usually all of us use non-AI code generation. It's not as smart as AI one, but does it apply the same as for AI?
Yeah, yeah. That's a simple answer. Yeah, it does.
I assume the answer would be depends. But
Any other questions? I have one. Is there, maybe you cannot say that, but something from like your real life experiences, some case that is like juicy AI related case that is shareable with us?
There was already one case in the Czech Republic, and I think it was a, let's say, made-up case just for the purpose to see what will the court think about the work generated by AI. So I don't think that it was really, let's say, true dispute, but there was some kind of a work. I think it was some kind of a picture, and it was generated by AI, and there was this dispute who owns the rights to that work, and it was a lower court. It was I think a municipal court in Prague. So it's not that, let's say, important decision. Is not the highest court, but at least some idea from that court side, and the court said that it wasn't a copyright work because there wasn't enough of human input. So that is the only case we know about in terms of who owns the rights to the work generated by AI. So that's why I'm more of a guy of the group who says that it will not be a copyright work if you use AI.
Okay, so you are more inclined.
Yeah.
Good. Yeah.
Sorry. So a lot of people don't read terms of conditions and these things. Maybe you do. So my question is, should we be aware about something in, let's say, ChatGPT before using that, and using the code generated there for our own purpose? Like, if we, as developers, create, let's say, 99% of the code and then add 1% from ChatGPT, does it should we be aware or be scared about something from that, like from using third party where we are not sure about what terms and conditions we agree to before using it?
I'm gonna right now answer with that standard response. It depends, but yeah, it really depends on what you're working on. I mean, if you're gonna use just ChatGPT for maybe the software you're developing or the work you're developing, because the terms and conditions of every single tool change over time, and some of them change really quickly, like once a month. So even with ChatGPT, I cannot say that right now you are okay with using that for that purposes, but you could not be okay in like a month or two. So it's hard to answer because we're not sure about the future, about the change in the terms and conditions, but there are already some limitations. For example, by OpenAI, there was this client who wanted to use AI that would put let's say generated text for and put it into let's say mouths of politicians, and that would be one of the cases that OpenAI doesn't approve of that because it would be for a political campaign. And with the upcoming elections in the US, OpenAI is very mindful of using ChatGPT for the political parties and political race. So if you were to use it for this kind of a purpose, then yeah, I would be afraid. But yeah, as I said, it really depends on the software you're developing.
Thanks.
Thank you. So Washe will be waiting for you at the speaker's corner, which is just outside of this room. And thank you, Washe. It was an amazing talk.
Thank you.